Without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I offer a resolution to authorize the issuance of subpoenas to compel the testimony of certain employees of the Bureau of Consumer Financial Protection. I call up the resolution and move its adoption. The clerk will report.
Resolution offered by Mr. McHenry to authorize the issuance of subpoenas to compel the testimony of certain employees of the Bureau of Consumer Financial Protection.
Without objection, the resolution is considered as read and open to amendment. I recognize myself to move to strike the last word and speak for 5 minutes. On March 6th, the American Banker published an article titled CFPB Staff Evaluations Show Sharp Racial Disparities. The article exposed serious personnel problems at the Consumer Financial Protection Bureau, including evidence that the CFPB's own managers have shown distinctively different patterns in how they rate employees of different races. On April 2nd, we held a hearing in this subcommittee to discuss the reported pattern of abuse. Testifying at that hearing was Angela Martin, a senior enforcement attorney who shared her experience of discrimination and retaliation at the hands of a senior-level manager, as well as Ms. Misty Ryuchi, an independent third-party investigator who was hired by the CFPB to investigate Ms. Martin's claim of retaliation. Unfortunately, the CFPB and the National Treasury's Employees Union refused to provide the requested witnesses to testify at the April 2nd hearing. And yet, as we maintain, it is imperative that we are able to question Ms. Bach, Ms. Strong, and Mr. Knopp. Through our investigation, it has become clear to this subcommittee that they are the 3 individuals with the most knowledge of the disturbing treatment which women and minority employees were subjected to at the Bureau. It should also be noted that these witnesses have had ample notice that the subcommittee would seek their testimony. On March 20th, the subcommittee invited Ms. Bach and Ms. Strong to testify at the April 2nd hearing. On March 24th, the subcommittee invited Mr. Knopp to appear as a witness at the same hearing after Robert Caldwell, the president of NTEU Chapter 335, declined to testify due to medical reasons. Prior to the April 2nd hearing, the CFPB refused to produce Ms. Bach and Ms. Strong, claiming to protect the employees' privacy expectations and maintain the confidentiality of the agency's deliberative process, and the NTEU refused to allow the testimony of either Mr. Knopp or Mr. Caldwell as well. Following the hearing, however, the subcommittee continued to seek the witnesses' testimony. By letter dated April 22nd, Mr. Knopp was informed that the subcommittee would notice additional hearings in furtherance of its investigation and that it would compel Mr. Knopp's appearance if he declined to testify voluntarily. Similarly, in a telephone conversation with CFPB staff on April 23rd, the committee's majority staff stated that the subcommittee would seek to compel the testimony of Ms. Bach and Ms. Strong if the CFPB did not permit them to appear voluntarily. At this point, the compulsory process is appropriate because the witnesses have indicated they prefer to be subpoenaed in light of their desire not to testify voluntarily. Ms. Bach and Ms. Strong retain counsel to represent them in connection with the subcommittee's investigation. Mr. Knopp is in the process of retaining counsel for the same purpose. Counsel for Ms. Bach and Ms. Strong have informed majority and minority staff that their clients preferred to not give voluntary testimony and therefore encourage the subcommittee to authorize and issue subpoenas. Similarly, in a telephone conversation with the committee's majority staff on April 23rd, Mr. Knopp also requested the subcommittee compel his testimony by means of a subpoena. Congress's subpoena authority is inherent in the powers to make law. Once authorized by the House and its parent committee, a subcommittee may compel testimony in a variety of circumstances, including to support Congress's power to legislate and appropriate funds, Congress's function of deciding whether or not to legislate, and Congress's oversight of the administration of laws by the executive branch, and the essential congressional function of informing itself of matters of national concern. We believe today's hearing, and markup is about those things. The subcommittee has a right to compel and receive the witness's testimony in this matter. The rules of the committee provide that pursuant to the rules of the House, a subpoena may be authorized and issued by a subcommittee in the conduct of an investigation, when authorized by a majority of the members voting and a majority being present. The subcommittee's investigation, like many inquiries throughout the history of the House, is for a proper legislative purpose, because it seeks to determine whether and to what extent agencies' maladministration has occurred and whether such problems have impaired the agency's ability to implement laws within its jurisdiction. I look forward to working with the ranking member, Mr. Green, and to the rest of the committee to further this investigation and get to the bottom of these disturbing reports of discrimination and retaliation at the CFPB. The ranking member is now recognized and moves to strike the last word and is therefore recognized.
Thank you. I so move, and I'm grateful to be recognized. Mr. Chairman, I am inclined to support the subpoena. However, I am not inclined to eliminate the existence of a CFPB. I think this hearing is quite timely in the sense of history, because we have seen a circumstance develop in our country where an NBA owner has said some very ugly things, and questions are being asked as to why people didn't act before this circumstance occurred, because there apparently was evidence of a need to act. Today, the league has acted, and they've given what appears to be the death penalty. But the question is also being asked, why are these actions, in terms of taking a closer look, being reserved for only one team and one manager? I think it's a legitimate question. I don't think we can assume that what occurred with one team may not be occurring in some other circumstances. So let me pivot now to the CFPB. I believe that we should have an opportunity to examine the circumstances. I am concerned about due process, but I think the circumstances should be examined. I also believe, however, that this is bigger than the CFPB. I think that the question will be asked of us at some point. Why didn't you look beyond the CFPB? Why did you allow a tree to prevent you from seeing the forest? Why, with empirical evidence and reports, did you not take a look at the other agencies under the purview of the committee? And I want to make sure that we don't end up today deciding that we are going to manage invidious discrimination as opposed to eliminate invidious discrimination, not only at the CFPB, but also across all of the agencies under the purview of the committee. And I say at the CFPB with some degree of reservation, because I think that there are many sides to stories, and I think every person is entitled to be heard before final conclusions are drawn. But I do know this: if we are not careful, we will allow what has attracted us to become a distraction, such that we get into a silo and we only look at one piece of a puzzle. We have a great opportunity. This is a pivotal point in history for us if we take advantage of it. Out of every adversity, there's an opportunity. The opportunity for us today is to look at what happened at CFPB, and we should, but also look at what may be happening in other agencies. Let me give some additional evidence to support my contention that this should be across the agencies that we are charged with supervising to some extent. The 2013 GAO report, styled Trends and Practices in the Financial Service Industries and Agencies After a Recent Financial Crisis, documented the extremely poor representation of women and minorities in leadership positions within the financial services industry and among federal financial regulators. According to GAO, industry representation of minorities in 2011 was higher in lower-level management positions, approximately 20%, as compared to 11%, thereabout, of senior-level management positions. While public attention currently is justifiable with reference to the CFPB, the most recent OMWI report suggests the disparities, impending internal upward mobility for minorities may be endemic throughout all the agencies regulating the financial services industry. According to the Treasury Department's 2013 Omni report, among its senior executive management, 86% are white men, compared to 7% black men, 4% Hispanic men, 3% Asian men. At the Federal Reserve, white men represent 48.7% of the executive senior level managers, compared to just 27.9% represented by white women. According to the most recent information from GAO, at the National Credit Union Administration, whites represent 88% of senior level management positions, compared with 4% represented by blacks and 4% by Hispanics. At the Office of the Comptroller of Currency, whites represent about 82% of the senior level managers, compared to 9% black and 5% Hispanic. Whites represent 89% of the senior level manager positions at the Securities and Exchange Commission, compared to 2% black and 5% Hispanic. Mr. Chairman, my point is this. I think we should seize this moment and do what should be done, and that is look at the entirety of the regulators and agencies that are under our jurisdiction. I will yield back.
Do any other members seek recognition or have amendment?
I'd move to strike the last word.
The gentleman from Wisconsin, Mr. Duffy, is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate the ranking member's inclination to join us today. And I take his words very seriously, who has been one who has fought racism continuously and has done very good work on that front. Just to maybe go off of what the ranking member was talking about, we've all heard of the comments that were recently made by Mr. Sterling from the LA Clippers, who is a Democrat, made absolutely offensive comments. And I am proud that the President stepped forward and condemned those comments. I'm proud that Reverend Al Sharpton on Meet the Press came forward and condemned those comments, and I think that was appropriate. I think we just learned today that Adam Silver, the commissioner of the NBA, has asked for Mr. Sterling to sell the team. Now, this is only a couple days since these comments, these horrible comments have come out. And I haven't heard anybody say, well, let's reserve judgment. Let's not do anything until we bring all the NBA owners in, all the managers in. Let's wait before we pass judgment. No. There was immediate condemnation, and there was an immediate request for Mr. Sterling to sell the team. But with the racism and sexism in the CFPB, I get concerned when we say, well, hold up a second. Let's not have quick, speedy action now. And to make the distinction as well, one is private enterprise, which is the LA Clippers. This is government, where we should have some oversight. And we should be able to move quickly in condemning what has been taking place at the CFPB. I know that Ms. Martin is here today. We all remember her testimony from a few weeks ago. The courage of a whistleblower to come forward and share her story of the retaliation in that agency, I think warrants all of us to stand together and push back hard. Not to say we have to wait for everybody else, and I'd agree with you, we should look at this everywhere in all of our agency. I am with you on that point. But we have a glaring example today. Horrible allegations in this agency with a white male director of racism and sexism. There is, I think we should have zero tolerance for this behavior. I'll join my friends across the aisle to look at this in every space, in every agency. But we have one example today, and we shouldn't let the broader purview keep us from moving quickly with regard to the CFPB. I know the kind of courage it takes, because I've had a chance to talk to Ms. Martin after her testimony, and it's my understanding that it hasn't stopped. It continues, and that's outrageous in 2014. And so I hope that we can come together, and frankly, I would hope that the President would come out and also condemn, like he did with the LA Clippers, condemn what's happening at the CFPB. That kind of leadership, I think, could move the ball a little bit further down the court, sorry the pun, and even if Al Sharpton would get involved and say, listen, we're not going to tolerate it, whether it's in the NBA or it's in the CFPB or any other agency. And so I appreciate the chairman bringing forward the subpoenas. I think to shine light, call this out, to root out the racism and the sexism, I think will make the CFPB a better place. And just to make one other point, off the ranking member's comments, you said that this doesn't mean we get rid of the CFPB. No one disputes that point. We don't dispute that point, but we're trying to make it a cleaner place. Just like no one is saying that we had racism from Mr. Sterling, and that means we're going to wipe out the NBA. NBA is going away, or we're going to make sure that we're going to clean out the LA Clippers. They're not going to have a team anymore. But we are making specific hard moves to address it immediately. And I think that same kind of immediacy, that same kind of passion, and the same kind of leadership that the president and other leaders who have fought for equality and have fought to fight racism, I would hope that they would come forward and help us in this effort. And I think this is a space that we have to join together in a bipartisan effort to root this out and to support leaders, not just for herself, but her agency and other co-workers like Ms. Martin. I look forward to that work, and with that, Mr. Chairman, I yield back.
For what purposes does the gentlelady from California seek recognition?
I defer to the gentlelady from Ohio.
For what purposes does the gentlelady from Ohio seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman, discrimination has no place in our society. And if done in the workplace, it can be against the law. Earlier this month in this subcommittee, we heard compelling and heartbreaking testimony from an American veteran, a public servant who is risking her career, sacrificing her privacy, and is courageously standing tall to further the CFPB's commitment to protecting financial consumers. I found Ms. Martin's testimony to be moving and credible, but unfortunately it's only one side of the story. We must hear responses from the Bureau directly. And while it is important to hear from individuals that may have specific knowledge of Ms. Martin's allegations, it is equally important to hear from the director of the Bureau, who wrote the subcommittee 2 weeks ago on April the 15th to offer his voluntary appearance in open session regarding this and other issues regarding the culture within this agency. In light of the American Banker's article from last month, it is critical that we investigate more broadly than just one employee's claims. This subcommittee must consider its examination in a thorough manner, and to do so in a way that rises above partisan political maneuvering. Racial, ethnic, gender-based, or other forms of discrimination within our federal agencies is an affront to all of the hardworking public servants that work for the American people every day. It is an affront to me. I will work with any member of any political party that is serious about finding and rooting out discrimination within the federal workplace. But that means two things. One, finding the whole truth, not just what may be politically useful, and two, actually working to craft reforms that resolve any issues that are uncovered. I will encourage us to not jump to conclusions, to not compare things that are apples and oranges, to not be swayed by political messaging and opportunities, and to not abandon our responsibilities on oversight and investigation. I will work to ensure that this subcommittee finds the truth and, if necessary, demand clear reforms that brings all of our federal financial regulators into compliance with the law and the common understandings of American decency. Therefore, although other members may vote as they see fit, I will encourage us to vote for fairness for all. Thank you, and I yield back.
Gentlelady yields back. Any other members seek recognition? The ranking member of the full committee. For what purpose is gentlelady?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman, and I appreciate your response to our request to have regular order in these proceedings. And again, I want to thank you for your interest in racial, gender, and age discrimination issues at the Consumer Financial Protection Bureau. I hope you will commit to addressing similar issues at our federal financial regulators and in the private sector with the same due diligence as you have at the CFPB. I'm just delighted to see my friends on the opposite side of the aisle providing leadership as we delve into what has been described as discrimination and racism and mistreatment of women. This is absolutely exciting to me that we have some new members on board in this fight against discrimination that has been raging for far too long in many, many places. While I believe the committee's role in working to determine the circumstances surrounding the allegations of retaliation and discrimination at CFPB are appropriate, I do hope that today's hearing can help us better understand the purpose behind these subpoenas. I believe that a transparent process makes for a better process. And Mr. Chairman, I'm hoping that we shed some additional light on your rationale behind issuing the subpoenas. I mean, subpoenas are extraordinary things. It's not something you do every day and often. So we want to know why the subpoenas are being issued in light of some of the information that we have. First, I'm hoping we can hear more about, again, subpoenas for these witnesses, why they're necessary. And as we know, the CFPB has offered both Director Richard Cordray and the Director of his Office of Women and Minority Inclusion, known as OMWI, Stuart Ishmaru, to testify before the committee without a subpoena. In addition, the National Treasury Employees Union has stated their willingness to offer their national president, Colleen Kelly, and local president, Robert Caldwell, to testify without being legally compelled. I hope that in today's hearing, we can better understand why the senior staff of both the CFPB and NTEU are an inadequate starting point for this subcommittee to begin to promote institutional change within the Bureau so that all of its employees are treated fairly and without discrimination. In addition, I'm concerned that the private counsels retained by the individuals in question were not officially notified in a letter from the committee inviting their clients to testify before today's subpoena markup was noticed. These individuals, should they be compelled to testify, should be afforded an appropriate amount of time to consult with their attorneys. And finally, I'd like to say that I hope that my colleagues on the other side of the aisle are as serious in addressing this type of discrimination as the Democratic members of this committee are. We have a long-standing and unimpeachable record against discrimination. Previously, we called on inspector generals at the Consumer Financial Protection Bureau and all other financial regulators to assess whether any personnel practices and policies have created an unfair or discriminatory workplace for minorities and women employees. And we were the architects of the OMWIs, who now handle all matters relating to diversity in management, employment, and business activities at the financial regulators. Already, the OMWIs have uncovered diversity issues throughout the federal regulators, which are again revealed in the most recent reports released last month. Finally, I'd like to ask my colleagues on the other side of the aisle to work with us in a more open manner to better understand and deal with this process. For example, I hope that future hearings will allow senior leaders at the CFPB to answer questions about the personnel problems. If we're going to seriously investigate racial discrimination, it must be done in a proper way to address the root causes, not to create a political spectacle. We're ready to work with you toward these goals. And I am inclined to support this subpoena today. And I'm going to be inclined to support subpoenas in other areas where we have problems, and we want you with us. We want you to stay on this track. We don't want you to just, deal with the CFPB here in the way that you're doing it. We want transparency. We want it to be open, but let's go forward now with a commitment to clean up government and make sure that racism and discrimination does not exist in any of our agencies. I yield back the balance of my time.
Do any other members seek recognition? Gentleman from Missouri.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, for the hearing. I think it was 1984 when I met the ranking member of the subcommittee at the King David Hotel in downtown Jerusalem. We've been friends since. But the important thing was, when I met him, he was the president of the Houston branch of the NAACP. I think he served in that capacity for more than 20 years. His credentials for standing up for people who are pushed down is impeccable. I join him. I will vote for the measure before us. I do have some serious reservations and some thoughts about it. One, my background is very similar, but I'm really nervous, Mr. Chairman, Mr. Ranking Member, that when someone comes to us from the SEC or from HUD or from the Fed or from OCC, and they say discrimination is running rampant in our agency, is this committee then going to take the testimony of one person who comes to us from HUD and then subpoena the secretary? I think we're moving through some crocodile-infested waters, and we are going to eventually be pulled under. I think this is very dangerous. It's difficult, however, to give any indication that one of the things I've been involved in most of my life is not of ultimate concern to me now. So, somewhere somebody's going to keep the minutes of this meeting, and everything that's being said today, I think will be regurgitated at some time that could create some discomfort for this committee. Yield back.
Will the gentleman yield?
Yes, I will, Mr. Chairman.
And I certainly appreciate your sentiment. I absolutely appreciate your sentiment, and I've appreciated my colleagues on this side of the aisle hearing the testimony of Angela Martin and giving it consideration, honest to goodness, real consideration, that the American people would be proud of Congress for doing that, for hearing it. The crux of this issue with the CFPB is the American banker piece and the review that this new agency did internally and saw enormous disparities. What we saw was a brand new agency establishing a very bad culture. And that's why we're trying to address it. I certainly have concerns about the management structure with the CFPB. We've been on the committee for the same amount of time, yes. So you've heard me say this. But what I've tried to do with this investigation is to take one step at a time. And so while Richard Cordray's testimony may be important at some point, the people that operationally know about the case and the matter at hand can answer questions. And this either can put it to rest or it raises more questions. So I want to be respectful, but we've tried to limit this in scope and to try to understand this and to see where we need to take it and not to jump to grand conclusions.
My last comment. No, thank you for your comments, Mr. Chairman. The Department of Agriculture was found guilty in federal court for intentional discrimination against African Americans and Latinos in a federal court, but the Ag Committee never got involved in it until afterward, and afterward all of us got involved because we had to vote on paying those farmers what the court said they were owed because of discrimination. And the Agriculture Department is, as I think all of us know, was called the plantation, but that committee never did get involved in it until after the federal courts. And so I'm going to vote for it. I don't think there's any mean-spiritedness going on here. I do think this is going to come back to haunt us. Thank you, Mr. Chairman.
Thank you. Any other gentleman from Minnesota? Move to strike the last word.
I move to strike the last word. And,
Mr.
Mr. Chairman, Ranking Member, I do intend to vote in favor of the subpoena. And I join my colleagues in having real reservations about the advisability of it. Not that I'm not very concerned and committed to rooting out discrimination at the CFPB or any agency. I think it's critically important. I also want to credit Ms. Martin, who's come before us and given very important, heart-rending testimony. But I am concerned that, are we going to undermine the internal processes? We want agencies to have internal processes to confront discrimination. If they don't work, are we messing around in the middle of of a lawsuit? And is that the proper role for Congress to engage in? I think the better role for a legislative body to be involved in is to look at systemic change. And so I hope that if this committee is going to be involved in rooting out discrimination, and I'm all for that, and I think it's the exact and right proper thing to do. The fact is, last time this committee dealt with the discrimination was on November 19th when the clear tenor of the committee hearing was to be in opposition to confronting disparate impact legislation. So now we're going to go in a different direction. That's fine. But it does bother me and does concern me about the precedent that we're setting right here. And I do want to add, just to make sure the record is clear, that one of my colleagues, I believe the gentleman from Wisconsin, felt it was important to point out the party affiliation of somebody who has absolutely nothing to do with this, Mr. Donald Sterling. I looked that up because I was curious, and I saw several articles that say, in fact, the gentleman was a Republican. I want to stand for the point that it is irrelevant what party anybody is in. We should be operating on the basis of trying to do what's right for the American people. I mean, far be it from me to start talking about who's in what party. I hope that is simply just a point of information and not meant to make any political point here, because it would be most unfortunate to turn this process into something that will favor one party or another in terms of discrimination. I mean, there have been a lot of high-profile, ugly things going on. Cliven Bundy, Phil Robertson, I believe he was a guest of one of our colleagues on the other side of the aisle. Nobody is trying to make a big deal out of that. Ted Nugent, I think he was a guest of one of our friends on the other side of the aisle. Nobody's trying to say anything about that. I want to stand for the proposition that we should depoliticize discrimination. There was a time when Republicans really were in favor of fighting discrimination. I mean, let's not forget that it was Dwight Eisenhower who sent federal troops to protect students as they were trying to enter a high school in Little Rock, Arkansas. Let's not forget these things. Republicans Abraham Lincoln was a Republican. We're in search of some Lincoln and Eisenhower Republicans. I mean, the fact of the matter is, though, is that this discrimination is serious business. I hope that this hearing inquiry goes far beyond just trying to cast the CFPB in a negative light. And I hope that we continue down this path of trying to make America fairer, more equal in terms of opportunity, and make sure that everyone has the full protection of the law. So with that, I yield back.
Without objection, Mr. Horsford and other members of the full committee that are not members of this subcommittee are authorized to sit on the dais. No. For what purposes a gentleman from Washington seek recognition?
I move to strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. Of late, I've been enjoying, for the umpteenth time, some of the wisdom of the genius of American politics, Will Rogers. I ran across a new one the other day. I didn't even think it was possible to read a brand new one. Maybe it was Mark Twain. Yeah, it was Mark Twain. He said, the two most important days in your life are the day you're born and the day you find out why. And then Will Rogers, that other great American, political genius once said, public feels about Congress is the same way they do when baby gets hold of the hammer. A subpoena is the hammer. It's the ultimate coercive tool, carrying with it presumably the potential for findings of contempt. And I come from a culture where that is a tool that is available, but should only be exercised in the most restrained and limited fashion. And I worry about its application in this instance, especially given that Mr. Cordray has offered to come in, especially given that the other gentleman who's the head of the Minority and Women Business Inclusion Office has offered to come in, especially given that there's a investigation both internal and I believe at EOC that is underway, especially given that this process is just on the front end of it. So I thought what I would do is go and look at, as it were, our constitutional guidance in this regard, the rules of the House and the rules of the committee. And lo and behold, we really don't have any. Subpoenas can be used any time a majority of the committee believes it helps in the furtherance of their investigation, period. No guidelines, no criteria, no suggestions, simple, pure majority vote. And I'm highly uncomfortable with that because I do believe that this is a tool that should be used very, very sparingly because it conveys a level of seriousness and appropriateness and, frankly, force of office. It should therefore have had adequately answered the question, why in this case? Is this the last resort? Have other remedies or avenues been utilized? But we have no guidance, no criteria. So I remembered something another great American said, whose name has already been invoked today, appropriate to this conversation. Dr. Martin Luther King, who said the long arc of history bends toward justice. And he helped me answer the second part of what Mark Twain suggested to me. Two most important days of your life, the day you're born, and the day you figure out why. There probably isn't a member sitting at this panel who in their own way feels on a cellular level some form of obligation, however varied from one individual to the other, to help bend that arc toward justice. And in that regard, what we're dealing with here in this instance, with respect to the allegations and the possibility of overt sexism and racism practices in the agency, the most important reason why we can vote yes today for this subpoena. But as I do that, it's my fervent hope, indeed prayer, that people would apply that standard, not just in individual cases, but across the board, to do what it is we can do to bend the long arc of history toward justice. Thank you, Mr. Chair. I yield back the balance of my time.
Do any other members seek recognition? Hearing none, we will then move into, anyone seek amendments?
I have an amendment at the desk.
Gentleman has an amendment at the desk. Clerk will, we don't have it. If we can distribute it first. Thanks. Yeah. The clerk will report the amendment.
Amendment offered by Mr. Green. Concern for
Mr. Chairman, I ask that the amendment be considered as read.
reserve the right to object. I would, if the clerk would continue to read. As I've never seen the amendment before, I at least want to have some idea of what the text says.
I concur.
For discrimination and retaliation in all financial agencies amendment. On page 1, line 1, insert the following. Whereas the Subcommittee on Oversight and Investigations is concerned about discrimination and retaliation with all other federal financial regulatory agencies under the jurisdiction of the full Financial Services Committee and will examine with equal due diligence internal personal.
I ask unanimous consent that we consider as read.
Mr. Chairman.
Mr. Chairman,
for what purpose does the gentleman from Wisconsin?
I'd like to reserve a
Mr.
point of
Chairman.
order.
Gentleman reserves a
Mr.
point.
Chairman.
The gentleman reserves a point of order. We'll now recognize the gentleman from Texas. For what purpose do you seek recognition?
Mr. Chairman, in the same spirit.
Move to strike the last word.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
I have a point of order that I wanted to call to your attention, Mr. Chairman.
Oh, well, then we'll restate it. The gentleman, sir, reserves a point of order, and you raise a gentleman.
I do.
Okay. Will the gentleman state the point of order?
You asked for unanimous consent, and I, in the same spirit of having this amendment read, agreed with you that it should be. I still maintain that we should finish reading it. So I ask that we continue to read.
Since there's been ensuing business,
well, the ensuing business occurred as I was asking to be recognized.
The gentleman raised his voice first. Well, I'll state it this way. Gentleman asks unanimous consent that we read the full text of it. We will read the full text of it. If there is no other objection, is there objection? No members have objection. The clerk will read the rest of the resolution.
With equal due diligence, internal personal practices, and any workplace policies within those agencies, and that may have created a discriminatory or hostile work environment for women and minorities.
Mr. Chairman.
Gentleman from Wisconsin.
Again, I reserve a point of order.
You reserve a point of order.
Mr. Chairman,
Gentleman from Texas. For what purpose does the gentleman?
To strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, this amendment is in the spirit of my friend from Wisconsin, who indicated that there is a desire to look beyond the CFPB, to look at other agencies. I think that this affords us an opportunity to go on record indicating that we desire to not allow this to become one agency. Rather, we would have this become an opportunity for us to examine other agencies. This will not require that it be done today. It does not mandate, but what it does say is that we can agree that there is an opportunity for us to do more than examine one agency. I have given you the empirics before, but I'll go back through some of them because I think they're important. It's important to note that at the Federal Reserve, white men represent 48.7% of the executive senior level managers, compared to just 27.9% represented by white women. I think that this means that there is some evidence that we can go beyond what we're doing with the CFPB. Like all of my colleagues, I think that any invidious discrimination in the CFPB has to be dealt with. But I don't think that we should find ourselves some years from now being criticized for having had an opportunity to look at these issues in other agencies and not having done so. This amendment, very simple, simply allows us the opportunity to look into other agencies with equal and due diligence, the same due diligence that we are according the CFPB, and we're going to look to see if there's any discriminatory or hostile work environment that's been created for women and minorities. With that, I would ask my friend, if I may, Mr. Duffy, may I engage you in a moment of colloquy? Mr. Duffy. Mr. Duffy? Yes, I wanted to engage with you in a colloquy. You've heard the amendment, and you've indicated that you have a desire to help as we move across all of these agencies. I'm asking you, are you going to work with us and support this amendment so that we can broaden this? We don't do it today, but we at least acknowledge that there's enough now for us to be concerned about other agencies under the purview of the committee.
Yeah, so I would support the amendment if it was germane. And I would tell you, listen, I'll join you in a good-hearted and good faith effort to look at racism and sexism in every agency. The conversation today with very clear specifics has been to the CFPB, which is what the hearing today is on. And I would hope that we could join together as a congressional family and focus on the CFPB. Let's go through this and let's then join together and look at other agencies. And I'm committed to continue that work with you. But
reclaiming my time,
yes.
I appreciate your comments, and I contend that the amendment is germane, and believe that if we are going to start this process, we ought not stop the process in one place. I'm with you. I think we ought to examine what's happening at the CFPB. But why do we stop there when we've had for years indications that we have problems there and elsewhere? There are other employees who want their stories told. They want to be heard. Is it fair for us to limit this to just one agency when we have all of this empirical evidence indicating that there may be problems in other agencies as well? So I'm going to ask you to join us. You've said that you are concerned. This is an opportunity for the committee to go on record showing that it supports employees in all agencies, not just one agency. And I will yield to the gentleman again.
I guess, and I'm newer to the committee, newer than you are. I guess I haven't heard any other allegations, and they may be out there, and I want to hear them if they are. But I mean, I haven't heard any other agency or subgroup in an agency that's predominantly African American be called the plantation. I haven't. Maybe that's what I'm saying. I could be wrong on that. I haven't heard that other than the CFPB. I haven't heard any other testimony.
Let me reclaim my time for a moment.
Witnesses like Ms. Martin. And if there are those, I would.
Well, let me reclaim my time, Mr. Chairman. Notwithstanding what you haven't heard, we have evidence to support the notion that there are other places where discrimination may be taking place. I mentioned the Federal Reserve. White men, 48.7%. White females, or females, white, 27.9%. And at the Securities and Exchange Commission, 2% black, 5% Hispanic in upper level management. Whereas we have 89% of the positions held by Anglos. So the question is, are we willing to do what we say, Mr. Duffy? And this is an opportunity for us to move forward together.
Gentleman's time's expired. Does the gentleman insist on his point of order?
I do.
Okay. The gentleman's recognized to explain his point of order.
Well, the subpoenas today are very narrowly focused on the CFPB and the racism and sexism at the CFPB. And so I would argue to the chairman that the amendment isn't germane. But I would note that I would like to work with the ranking member on other issues of racism and sexism and any other war on women that's going on out there. I think it's important. But my argument goes to the focus today on the CFPB. This would expand that focus. That makes it not germane. I yield back.
All right. The gentleman, does Mr. Green, do you seek to be recognized on the question of germaneness?
I do.
The gentleman is recognized.
Mr. Chairman, germaneness is really in the eye of the beholder. It really is.
I'm sorry.
After we distill this down to its essence, the question is really this: do we want to root out invidious discrimination, or do we want to manage it? We can manage it by looking at cases one by one in one area, or we can root it out and end it. I'm for the elimination of invidious discrimination, not the management of it. And I fear that whether by accident or design, if we continue down this path, we will find ourselves managing invidious discrimination.
Well, if the gentleman will yield on this point,
I will yield to the chair.
I would pledge to work with the ranking member on this matter. As I stated in my opening statement and my colloquy with our colleague from Missouri. It is my intention, with the narrow focus of this subpoena, to compel the witnesses that have refused to testify, that have requested to be subpoenaed in order to testify about the matter, and to keep this as narrowly focused on this matter to get to the heart of it. And that is in the nature of that. And so I appreciate my colleague offering the sentiment. And if he wishes to seek this out, this is not the right subpoena in order to add this language. It changes the nature of it, and I'm prepared to rule.
I would like to reclaim my time before you rule. Okay. Well, let me just share this thought.
So
before you rule, Mr. Chairman, it's my time.
Well, it's gentleman's time. Go right ahead. Okay. So, gentleman yields back, and in the opinion of the chair, the amendment is not germane. Pursuant to Clause 7 of Rule 16 of the House, the point of order is sustained.
Mr. Chairman, I now move that we table the point of order and ask for a recorded vote.
The question is whether the decision of the chair shall stand as the judgment of the committee. In the question is on the motion to table. All those in favor say aye. All those who say no.
No.
Okay. In the opinion of the chair, the ayes have it.
No.
So,
excuse me.
I ask for a roll call vote.
There's been a roll call requested, and a sufficient. Okay. Clearly, more than 1/5 present clearly state that they wish to have a roll call vote. And so, at this point, we will recess
Mr. Chairman,
to. Seeing as we have 2 votes on the floor, and it is apparent that we will have 2 votes in committee, we do not have time to conduct the vote. So. With that, we'll stand in the recess until...
Mr. Chairman, a point of order, please.
Gentleman will state his point of order.
Is this not a vote that has to be taken immediately? And given that we have members present, and it's been my understanding that all votes would be taken immediately? This point of order should be taken immediately. Is that not what the rules require, Mr. Chairman?
Take the vote.
Okay.
Come on, quickly.
The question of tabling the motion has to go before every additional piece of vote in committee. So therefore, when we return, we will have that vote and then follow it up by final passage.
I ask that the record reflect my dissent, Mr. Chairman.
Committee's in recess. Committee will come to order. Committee will now come to order. Without objection, the motion to table is withdrawn. And without objection, the appeal of the ruling of the chair is withdrawn. And without objection, and without objection, the amendment from Mr. Green is withdrawn. Now, for members' attention, the chair will announce that we were informed during the recess that the Democrats on the committee had a total of 4 amendments that they were going to seek today. And after staff review and now my personal review of these 4 amendments, they are in keeping with the spirit of what this Congress and this committee is about. It is language that could have been affected had my colleagues on the other side of the aisle had reached out to the majority staff within the last week once this hearing was noticed, and could have been incorporated into the written text of the resolution. Even if my friends on the other side of the aisle had come to us within 5 minutes of gaveling in, we could have dispensed with this, and members' time could not have would have been better utilized with other things, and we could move forward in a bipartisan way on this investigation. I'd like to recognize Mr. Green for the 4 resolutions that he is going to offer en bloc.
Mr. Chairman, if I may, before you do that, I'd like to have what I think is a fair opportunity to respond to your commentary. I think, Mr. Chairman, that commentary was not in the spirit within which we offered the resolutions, and we agreed. To make those comments makes it appear as though the members on this side were less than honorable. And if we're going to say things like that, I don't think it helps us with our efforts to achieve bipartisanship. So now my assumption is that you're not saying that we were less than honorable, that you are indicating that we have an agreement and that we're going to go forward with our agreement rather than get into a debate about why we find ourselves in this position. With that said, Mr. Chairman, I have 4 amendments at the desk, and I would seek to offer all 4 amendments at this time.
Without objection, all 4 amendments will be offered en bloc.
Mr. Chairman, with the remainder of my time, I'd like to just briefly explain what the amendment is.
Well, gentlemen, just for clarification, does the clerk have, the clerk has 2.
Yes, the chair. The clerk only has 2 amendments.
We're prepared to pass the other 2 over, and
we just need those.
We'll wait.
Oh. So the clerk. The clerk will report. And we'll share that with the Republican side of the aisle as well, if we could. It's fine. I've seen him. Yeah, let's make sure everything's the same. Clerk will report.
Amendment offered by Mr. Green. Members of the subcommittee required an office of
Ask unanimous consent that the amendment be considered as read. The gentleman, Mr. Green, is recognized to strike the last word and is recognized for 5 minutes to explain his 4 amendments.
Thank you, Mr. Chairman. Mr. Chairman, Amendment number 1 indicates that we would, meaning the Financial Services Committee, examine with equal due diligence the internal personnel practices at any workplace and any workplace policies within the agencies that are under the purview of the committee. And we're looking to see if they create any discriminatory or hostile work environment for women and minorities. The second amendment would have the OIG exercise its independent oversight authority over the operations of the Consumer Financial Protection Bureau to detect whether any personnel practices and policies have created an unfair or discriminatory workplace environment for women and minorities. The third amendment would add language connoting that the Director, Richard Cordray, of the CFPB, notified the subcommittee that he would voluntarily make himself available to testify before the committee on matters related to these issues. And the fourth and final one indicates that we have Ms. Kelly, who is the president of the National Treasury Employees Union, has informed the committee that she and Mr. Caldwell, the president of the NTEU, Chapter 335, are willing to testify on allegations of discrimination and retaliation at the CFPB. I will yield back, Mr. Chairman.
I move to strike the last word. I certainly appreciate the ranking member offering these amendments. I appreciate the willingness at the staff level to have discussions about this language, and I appreciate the ranking member of the full committee and the ranking member of the subcommittee for working through these issues in the ensuing recess that we had. And I certainly appreciate their willingness to work on this specific investigation that is at hand today, that involves the discrimination and then the retaliation upon Angela Martin and those individuals that are in what we believe the proper positions to know the details of what happened in her case. And as I said in my opening statement when we started this markup earlier, that the idea here, the intent here, is for us to get to the bottom of this investigation, to know what happened in this particular circumstance and find out the truth. And in that endeavor, it is clear that both sides of the aisle are in agreement that we want to get to the bottom of this. We want to make sure that the CFPB is abiding by the law, that their rules and regulations and the staff decisions and the leadership are making good decisions that do not harm those that are working for the Bureau.
Will the Chairman yield?
Sure, I would be happy to yield.
Thank you, Mr. Chairman. I'm pleased to hear you give those indications, and quite frankly, I find favor with them. But I would also add that by virtue of what we're doing, we're indicating that we're going to have a broader vision, that we're not going to just look at one area, that the opportunity is here for us to avoid the management of invidious discrimination and deal with the elimination of it. While this does not require a mandate that it be done in a subpoena, and I agree that it shouldn't, it does afford us to go on record as saying that this committee is not going to tolerate invidious discrimination in any of the agencies under our purview, and that we are amenable to having the proper authorities investigate and give us some indication as to where we are with invidious discrimination.
I appreciate the gentleman's comments, and as I was going to wrap up in consideration of the amendments before us, the language that the gentleman has put forward is certainly constructive to our investigative authority within this committee and within Congress. I think it is important that Congress exert a proper check and balance upon the executive branch to ensure that they are faithfully executing the law, including, and most importantly, the fairness aspect, and that is to ensure that individuals are not discriminated against, that individuals are not, their bosses are not breaking the law, and I think that's certainly important in all the regulators. The CFPB is a new creation and has only been a freestanding agency for but 2 years. So it's important that the culture be right in this important agency, and we are going through the process first of going through the CFPB. And so I certainly appreciate the amendments, and I ask that members support the amendment, and would now ask the question on agreeing to the amendment that have been presented en bloc. So those in favor, please say aye. Aye. Those opposed, say nay. In the opinion of the Chair, the ayes have it.
Mr. Chairman,
the ayes have it. The amendment's agreed to.
Mr. Chairman, I believe we want a roll call vote on the amendments.
The gentleman asked for a roll call vote, and those in favor will raise their hands and be counted. A sufficient number having been raised, the recorded vote is ordered. The clerk will call the roll.
Mr. Fitzpatrick. Aye. Mr. Fitzpatrick, aye. Mr. King. Aye. Mr. King, aye. Mrs. Bachman. Aye. Mrs. Bachman, aye. Mr. Duffy. Aye. Mr. Duffy, aye. Mr. Fincher. Aye. Mr. Fincher, aye. Mr. Hulkren. Aye. Mr. Hulkren, aye. Mrs. Wagner. Aye. Mrs. Wagner, aye. Mr. Barr. Aye. Mr. Barr, aye. Mr. Rothfuss. Aye. Mr. Rothfuss, aye. Mr. Henserling. Aye. Mr. Henserling, aye. Mr. Green.
Yay.
Mr. Green, aye. Mr. Cleaver. Mr. Cleaver, aye. Mr. Ellison. Mr. Ellison, aye. Mr. Perlmutter. Mr. Perlmutter, aye. Mrs. Maloney. Mrs. Maloney, aye. Mr. Delaney. Ms. Sinema. Ms. Sinema, aye. Mrs. Beatty. Mrs. Beatty, aye. Mr. Heck. Mrs. Waters. Ms. Waters, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report.
Mr. Delaney.
Pardon me.
Mr. Delaney, aye.
All right. Any other members? Clerk will report.
Mr. Chairman, the ayes are 20 and the nays are 0.
The amendment is agreed to. A majority having voted in favor of the amendment is agreed to, and without objection, a motion to reconsider is laid on the table. The question occurs on the adoption of the resolution. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the Chair, the ayes have it. The ayes have it. The resolution is adopted.
Request a recorded vote, Mr. Chairman.
Gentleman requests a recorded vote, and members, those in favor of a recorded vote, please raise your hands. 1/5 in the affirmative. A recorded vote will be called. Clerk will call the roll.
Mr. Fitzpatrick. Aye. Mr. Fitzpatrick, aye. Mr. King. Aye. Mr. King, aye. Mrs. Bachman. Aye. Mrs. Bachman, aye. Mr. Duffy. Mr. Duffy, aye. Mr. Fincher. Aye. Mr. Fincher, aye. Mr. Hulkren. Aye. Mr. Hulkren, aye. Mr. Barr. Aye. Mr. Barr, aye. Mr. Rothfuss. Aye. Mr. Rothfuss, aye. Ms. Wagner. Aye. Ms. Wagner, aye. Mr. Henserling. Aye. Mr. Henserling, aye. Mr. Green.
Okay.
Aye.
Mr. Green, aye. Mr. Cleaver. Mr. Cleaver, aye. Mr. Ellison. Mr. Ellison, aye. Mr. Perlmutter. Mr. Perlmutter, aye. Mrs. Maloney. Mrs. Maloney, aye. Mr. Delaney. Mr. Delaney, aye. Ms. Sinema. Ms. Sinema, aye. Mrs. Beatty. Mrs. Beatty, aye. Mr. Heck. Ms. Waters. Ms. Waters, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Any members wish to change his or her vote? Any members? Clerk will report.
Mr. Chairman, the ayes are 20 and the nays are 0.
Majority having voted in favor of the resolution is adopted. Without objection, all members will have 2 legislative days to submit additional materials to the Chair for inclusion in the record. I thank the members for the bipartisan nature of today's hearing, and no further business being before the subcommittee. We stand adjourned.